Welcome back to RICO Busters, the show that spotlights corrupt government officials, the criminal usurpers of the power and authority of we the people, and their racketeering network constituting local, state, and interstate crime syndicates of domestic terrorists. In this brief episode, we focus once again on the racketeering being conducted throughout the so-called state of Michigan, being in this case the showing to you, the audience, how the Michigan Department of Health and Human Services operates feloniously through what they deem to be their own administrative process, while using what really amounts to state and federal deprivation of rights crimes that are carried out through simulated legal process. This video shows how the corporate state, referring to itself both as a company and a state, utilizes corrupt administrative law judges employed by the Michigan Department of Licensing and Regulatory Affairs to railroad what are otherwise fraudulently deemed by them to be impartial administrative hearings. So come on in and join me, your RICO Busters host, David Scheid, as I take you through what exactly the administrative process looks like in the great corporate state of Michigan. Despite that its own constitution had long ago stipulated that the legislature itself should not pass any act of incorporation unless with the assent of at least 2/3 of each house, and the federal constitution for the government on behalf of the people of the United States mandates under criminal penalties that each American national be accorded his just right to due process. We will start with a little background to this story. The longer version is the story of how a small startup family new to Michigan in 2003 was callously destroyed by treasonous Michigan government usurpers, operating at all levels of offices, from the local public school district officials through multiple county and state courts, right on through the executive and judicial branches to the highest offices of the past 2 state governors and state attorney generals, the Michigan Supreme Court, and the past 3 state court administrators and their associates in power who have long been running the so-called state of Michigan as being all members of the statewide crime syndicate and domestic terrorist network known as the State Bar of Michigan. The bottom line from that longer version of the story is that challenging the system and the powers that be cost me everything. It cost my career as a fully credentialed public school teacher, my life savings, my health, and eventually the ability to support my dependent other family members. I was forced for the first time in my life to be dependent upon the state for health care and for food. Had it not been for the grace of God and the willingness of my disabled now ex-wife and I to defy the destructive intent of the state by working together to keep our sons safe and warm, the roof over our heads would have also vanished several years ago. It was eventually that joint defiance, our joint willingness to tell the state of Michigan to go to hell when they continually demanded using the hard-earned wages of my learning disabled ex-wife employed as a maid because the state refused to approve her alone for state assistance, while on the other hand approving my application simply because I am more capable than her in completing the state's mound of computer application pages. The key premise of this story is the audience understanding that government, not we the people, are bound by the state and federal constitutions and the laws that we the people have implemented through our legislators. The key problem we must contend with is that our so-called government sees things as being the other way around, and that they hold great latitude for their official acts of discretion. Those in our government offices are under the delusion that they are not to be held accountable to us, being we the people, who have created and ordained government in the first place, and holding forever the original power and authority from which their entire existence is derived. Thus, when those operating under the assumption of government power commits acts that exceeds the bounds of what power and authority that we the people have delegated to them, their acts become unenforceable at the very least when applied against us. when those acts are so outrageously abusive as to deprive we the people of our inalienable and unalienable rights as American nationals, they become criminals, such as by intentional torts, by deliberate gross negligence, malfeasance, or worse, by a sophisticated conspiracy to deprive any one of us of our rights. One of the most important of those rights is our due process rights. Another is our First Amendment right to redress of grievances through successive levels of what is popularly known as the appeal process. This story shows how that appeal process is railroaded, as is the pattern and practice of those members of the State Bar of Michigan operating the courts and the administrative proceedings, and about which so many inhabitants of Michigan have been increasingly experiencing. Another key premise for this story is the fact that with the directive that legitimate governments obey the state and federal constitutions and the laws, to which they are obliged to swear their oath and guarantee their faithful performance with a personal performance bond, is the concurrent directive that legitimate governments prove their performance through transparency. Hence, all actions by government are to be documented as being in compliance with state and federal laws, written policies, and rules of procedure. This is particularly important in compelling government to prove that they are not violating the rights of Americans in any way, nor stepping outside the bounds of their enumerated fiduciary rights to become, collectively, an oppressive or tyrannical government. Thus, we have both state and federal laws pertaining to government transparency known as the Freedom of Information Act, to which government officials must be strictly attentive to and reasonably responsive. This story shows the reason why the state of Michigan was rated F by the Center for Public Integrity, ranking dead last, number 50 out of 50 states in public integrity. And with the failing lack of public access to information, the failing civil service management, and the failing enforcement of ethics by oversight agencies such as the Michigan Attorney General being integral to Michigan's abysmal score. In fact, because the state itself does such a poor job in its self-regulating, its self-policing, its self-reporting, and its self-correcting and or prosecuting its criminal offenders, I used a combination of hidden camera and Freedom of Information Act, or FOIA request, to capture what the government itself refuses to reveal in its sinister mode of operating as tyrants, as criminal racketeers, and as domestic terrorists.
What's your name? Mr. Scheid?
Yes, I'm David Scheid. We begin this story with a bit of an overview of what we are about to see from the perspective of a hidden camera and microphone. The event was the first of several, what the Michigan Department of Health and Human Services calls a pre-hearing. That is supposed to be a good faith meeting of the parties to see if there can be an attempt to work out the problem before engaging an objective third party, an administrative law judge, in a full-blown nonpartisan hearing to determine the facts of the case and to arrive at the determination of whether or not the department, the DHS, has properly acted to deny services and or to close the case of my receiving state aid in the form of a food assistance program. Here, I am about to meet two people from the DHS that I have never dealt with before. And as you'll see, when I ask why the person S. Lilly, the DHS specialist and case manager who was responsible for denying services and threatening to close my case, is not present to discuss the matter, or why neither she nor her supervisor seem to have accountability for these actions taken against me, the DHS manager, Benjamin Smith, supported by his sidekick, a hearing facilitator by the name of Michelle Silas, literally tells me that he, the DHS, does not have to be cooperative with me at this pre-hearing, but that I must be cooperative with him. Watch.
What's your name?
Mr. Scheid?
Yes, I'm David Scheid. Just getting ready to walk out the door.
Come on in. You can have a seat on the other side of that bench right there. Mr. Scheid, I'm actually in the front, and I'm a manager here.
Okay.
And you have requested a hearing.
Oh, this here.
Yes, sir. So this is a pre-hearing.
Yes, and who's this?
This is Miss Silas.
Silas.
Right.
Okay.
If we go to the hearing, she'll be handling the hearing. You've asked for a hearing. This is the pre-hearing. We'll decide where we're going to go from here. You can either withdraw here today if things go the way you'd like them to, and if not, the hearing will be scheduled within 90 days of the day that you requested it, and you'll get a notice about that. Normally they don't take up to 90 days, more like 60, but you'll get a notice that the hearing has actually been scheduled, okay?
Can you tell me why S. Lily is not here? She's been the one that I've been dealing with. I'd like to know why she's not here to help arbitrate this
She doesn't.
situation.
We don't require that the workers who take the action, even the case was in her name, we don't require them to be here at the pre-hearings or at the hearing.
Can I get your
The
business
manager-
card?
I don't have a card, sir.
You don't have a card? Could,
So what we're going to do,
would you write your name on this, please? Thank you. And what's your first name again?
is Benjamin.
Benjamin. And who is Good? S. Good.
That's Miss Lily. Her name changed.
Her name changed. Okay. I wish that you had told me that when I asked for Miss Lily.
I don't see how that has any bearing on it.
Well,
it really
if-
doesn't have any bearing on it.
Names are important, don't you think?
Not necessarily, sir.
It has to do with accountability.
Okay. That's not what we're here to discuss. We're not here to discuss names or who took what. We're here to discuss an action that was taken, and that's what we're going to stick to, okay?
By S. Lily.
By the Department of Human Services. Okay?
And one of the person, sir, I'm going to ask another question because
one more question.
I'd like to know who it was that I spoke with on the phone who said that they were a supervisor of S. Lily at the time.
I can't tell you that. I don't know. It was Mr. Williams?
That was Mr. Williams? Okay. And what is his name, first name?
Mr. He's a supervisor here.
Mr.
Mr. Williams.
Mr. Williams. His first name is
Mr. Williams. His name is Mr. Williams.
First name is Mr.
Okay. Now, let's go on with the pre-hearing here.
Okay.
We're going to discuss the action that we took, which was
actually,
basically sir, Mr. Shy. How do you pronounce your last name?
Names don't matter, do they?
Sir, how do you pronounce your last name?
I asked
being
you.
very cooperative.
Neither are you. I asked for Mr. Williams' first name, and you gave me Mr. as his first name.
That's right. I did.
So we are going to both be cooperative, sir.
No, sir.
Oh, you are
Stop
not?
this and be cooperative, and we're going to discuss your hearing request, or we'll just dismiss this and go to the hearing level. In fact,
That will be fine with me, sir.
Okay. FOI request, this information that you requested,
SOI?
Freedom of Information.
Oh, FOIA
You
is
have
what I call.
requested information?
Yes.
That's the packet of information.
All right.
Okay?
Yes.
All right, sir. We're done, and you will receive a notice that the hearing has been scheduled.
All right.
Okay? And that will be probably within the next 3 to 4 weeks, I would imagine.
All
As many as 6. But it has to be scheduled within 90 days of your request. Okay, sir?
Okay, so you're going to schedule it and send me a notice?
I don't schedule it, but you will receive a notice.
All right.
All right, sir? Yes, we are going to give you. This is our case. You requested the hearing, and this is our case.
Okay.
All right? You'll have a copy, we'll have a copy, administrative law judge will have a copy.
All right.
And if you would, sir, please.
I will not sign anything today.
Very good. You have a nice day.
So much for good faith as the state of Michigan's attempt at conflict resolution.
Holy moly, 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 holy moly.
Let's fast forward 3 weeks later to September 15, 2016, to the so-called administrative hearing I was having against the DHS, a hearing that I had been misled to believe was being held before an impartial administrative law judge that was supposed to be under employ as an actual judge, i.e., one that had subscribed to an oath to the Constitution as the legitimate judge, and representing the Michigan Department of Licensing and Regulatory Affairs. What follows here now is a segment from that hearing, as I obtained the official recording of that day's hearing of the Administrative Law Judge Christian Gardocki, which I got through my subsequent Freedom of Information Act demand for this digital recording from the Department of Licensing and Regulatory Affairs. It demonstrates not only the blatant fraud and perjured testimony of both Smith and Silas when blaming me for the breakdown in communications at the pre-hearing that you just finished watching. It also demonstrates the crooked disposition of the administrative law judge to twist the procedural elements of this proceeding so as to deceptively conduct his official questioning as a matter of record under mere color of law and procedure, so as to deprive me substantially of my due process rights and proper due process in the exercise of my First Amendment guarantee to a meaningful redress of my grievances about this entire circus of proceedings taking place, otherwise geared to railroad this case in favor of the DHS and the corporate state of Michigan.
Mr. Scheid, my question was, is there a document you don't have that prevents you from participating in today's hearing? That's what I would like to know. And if you're unable to answer that and you're unwilling to participate, then I am going to dismiss your hearing request.
All right, I believe that
and I still like the idea of trying to conduct a hearing, and then if you don't have something or if something is submitted that you weren't aware existed, you can raise an objection at that time, Mr. Scheid. That's part of the hearing process.
I've already raised my protest and objection. I will tell you again, I object and protest to these proceedings taking place today because I am owed, number one, a meaningful, period, and fair opportunity to seek relevant and needed documents in a timely fashion and without the involvement of fraud during my preparation for an administrative hearing. Number two,
I know, but that keeps going back to my question.
A meaningful
What
pre-hearing conference. A meaningful pre-hearing conference in accordance with the representations made in writing by DHS so as to coerce me to pay for transportation to and from their office in good faith.
Mr. I'm going to cut you off. Mr. Smith, was a pre-hearing conference scheduled?
Yes, sir.
Did Mr. Scheid appear for the pre-hearing conference?
Yes, sir.
And did DHHS attempt to have a meaningful pre-hearing conference with Mr. Scheid? How did that conference go, Mr. Smith? What do you recall from that?
We didn't get very far, sir, and I ended the pre-hearing conference. We couldn't get past first names.
Okay, so I recall Mr. Scheid mentioning that he was asking about Mr. Williams' first name. Was that part of the hang-up?
Yes.
And what do you recall happening?
Well, I couldn't understand the relevance to it. I tried to get him to explain the relevance of it, and he went off on a tangent. It became apparent soon after that that we were not going to be able to address the issue of why we were having the pre-hearing. So I ended the pre-hearing and told him that we will that the hearing would be scheduled.
Okay. And Ms. Silas, were you present for that?
Yes, Your Honor.
Do you recall anything differently or additionally?
No, Your Honor.
And I didn't swear you to it. Ms. Silas and Mr. Smith, well, Ms. Silas, do you have any objection with being sworn in?
No, Your Honor.
Mr. Smith, do you have any objection?
No, Your Honor.
All right, let me swear you in. Do you swear, raise your right hand. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Smith, your response.
Yes.
Ms. Silas, your response.
Again, I object to the proceedings because they did not say anything about, and they probably won't, about the belligerent attitude of Mr. Smith, saying that he was that he didn't have to DHS. He doesn't even have personal accountability for anything. All this stems from dealing with personal accountability of every government official that's in this building. That when I'm asking for personal accountability, there's such a thing as performance bonds, there's blanket bonds, there's errors and omissions insurance, there's all kinds of stuff that's supposed to assure the so-called taxpayer that these people have personal accountability for their positions and their oath of office. So what I have done is I've asked for a little bit of personal accountability here, and they want to, through him, is to use the term DHS. DHS is the one that has the accountability. It doesn't have anything to do with any people. So when I'm asking for a person's name, I'm entitled to a person's name, especially if that person is going to be calling me on the phone in the summertime and supposed to be handling this matter. If I want to call that person in, if I want to refer to that person in any of the documentation, I have every right to do so, sir. And when I get belligerence in return on what's supposed to be called a pre-hearing, in which I have been informed that the purpose of this in writing, and I've, based on good faith, driven here on my own accord, in good faith, that this is going to be honored, I'm entitled to that. It's not optional. It's not their discretion to give that to me or not. I'm entitled to it. It's in writing. It's part of the administrative proceeding.
I understand, Mr.
Okay.
Scheid. Now let me say this. I somewhat agree with you. Government and its employees should be personally accountable. Let me say this, though. The question, I think, or the difference we may have, Mr. Scheid, is what is the remedy for it? In your mind, the remedy is to not participate in the hearing and allege fraud and send countless letters to, I guess, the hearings office and presumably other DHHS employees to complain about it. I don't think your response justifies the alleged lack of accountability. I don't think it justifies what you did. I don't think that excuses you from a hearing today. And I think if you're using that to not participate today, it's going to be a wrong decision, which is why I'm trying to have a hearing and see if you're willing to proceed. At this point, I think we can, because I haven't really been given a reason why we shouldn't.
I told you that there's 2 months down the line, I'll be here. Is that funny, sir? I tell you what, I'm not laughing about any of this. And you didn't let me finish just a moment ago when I was going to tell you that, again, as a matter of the record, that Mr. Smith said we, at the DHS, do not have to cooperate with you. You have to cooperate with us. Okay? No personal accountability. This is big bully government on my butt.
We're going to discuss the action that we took.
Actually,
what is Mr. Scheid? How do you pronounce your last name?
what names don't matter, do they?
Sir, how do you pronounce your last name?
I asked you, neither are you. I asked you Mr. Williams' first name, and you gave me a Mr. as his first name.
That's right, I did.
So we are going to both be cooperative, sir.
No, sir.
Are going to both be cooperative, sir.
No, sir.
Going to both be cooperative, sir.
No, sir.
Now, you may recall that at the first appeal hearing conversation in September 2016, I had stated that I needed 2 more months to be fully prepared for the actual appeal hearing. This was not only because the DHS had tactfully given me little notice prior to scheduling a hearing date, but also because I had submitted FOIA demands for documents that they would be using against me. Now, in the video, you saw DHS manager Smith hand me an envelope with some of those FOIA documents enclosed. But once I perused those documents in the comfort of my home, I discovered that package to be incomplete. For instance, those documents inform me that while DHS intended to use certain written procedural policies against me, they only provided a limited number of pages and sections of those policies, without providing me the fuller context of their operation and intent against me. So I demanded more. The problem was that from the time of my initial FOIA request, demand, for documents, the DHS blew me off completely, failing altogether to provide me with anything for 2 full months, being a violation of Michigan's FOIA laws. So what am I going to do? Take them to the corrupt Michigan courts at my own cost in hopes of getting remedy from a system that I already know is run by more criminal racketeers? Here are the facts, and the strategies used by corrupt fiduciary officials to sidestep the substantive requirements of the law by using procedure to undermine the people's right to due process of law with regard to failing to produce FOIA documents and depriving we the people of true government transparency. Both constitutional scholars and the federal courts are well familiar with the fact that there is great tension between how rules, procedures, and policies are supposed to work to guarantee substantive rights and how they are otherwise misused to deprive people of those rights instead. In 1934, the United States Congress founded an act called the Rulings Enabling Act of 1934, which was codified to 28 U.S.C. Section 2872, which stated this: "The Supreme Court of the United States shall have the power to prescribe by general rules the forms of process, writs, pleadings, and motions, and the practice and procedure in civil actions at law." Here's what's important. "Said rules shall neither abridge, enlarge, nor modify the substantive rights of any litigant." That's you and me, folks. So what's the pattern in practice that the so-called government uses to circumvent and undermine FOIA laws? Number one, they completely ignore the request and leave it up to we the people to either take them to task on their dereliction and criminal gross negligence or to resubmit the same request again. Number two, they deny the request altogether, or in the alternative, they grant the request but provide a general website where they claim that the documents can be eventually located if you spend forever searching for them. Number three, they grant the request but send you something completely unrelated to your request. For instance, here is where DHS answered my request about the relationship between the Department of Health and Human Services and the Department of Licensing and Regulatory Affairs administrative judge conducting kangaroo hearings on the DHS's behalf. The fourth strategy I saw being implemented against me was when they determined that my request was too broad and the documents were too many to provide at a reasonable cost. This is in spite of the fact that the documents I had requested were merely those that the DHS indicated their intent to use against me, which must have been a manual so thick with policies that DHS employees could not possibly follow all of these policies in the strictest sense anyway, even if they wanted to. In any event, DHS claimed that my unreasonableness in demanding transparency in their intentions against me should cost me an arm and a leg. They attributed it to their cost of locating and copying these documents, which DHS should already have had handy since they are claiming to be using these policies against me. The bottom line? The 2 months period came and went, and the DHS charging me for overpayment of benefits for what they claimed I received in ongoing payments after they had decided to deny me, based on my ex-wife's ongoing refusal to allow them to screw with her employer, her earnings, and her life, and while I was spending this 2 months period of time appealing their initial denial of my benefits. Moreover, despite that my alternative was to take them to court if I disagreed with them, they announced their intention to collect upon me without any judicial process whatsoever, by threatening to administratively issue liens and wage garnishments against me, and my ex-wife, and against my son, simply because they were in the household, as the DHS elected to define that term by the IRS's definition. Yet I insisted that the term household itself was subject to interpretation based upon the divorce decree I held, which was the judicial action that specifically separated her household and her belongings from mine as it regarded custody and the cost of caring for our dependent child. So let's get back to the first of 3 administrative hearings that were conducted by the notorious Michigan Administrative Hearing System, as run by the State Bar of Michigan managerial member Christian Sepinen and his fellow bar member Christian Gardaki, the administrative law judge who failed to reveal until after the first administrative hearing the fact that he was acting on behalf of Nick Lyon, the director of the DHS, being my opponent at that very same hearing. Note that Nick Lyon was an appointee of the illustrious Governor Rick Snyder and that his predecessor was Mara Corrigan, a criminal operant formerly the chief of the Michigan Supreme Court. So you can see how incestuous this whole Michigan government gets, with bar attorneys and judges taking their turns in tag team fashion running the affairs of the state, in such fashion as is seen herein during the proceedings taking place before this hidden video camera. Here is my introduction to the administrative law judge, Gardaki. I begin by letting him know that in my latest correspondence to his boss, Christian Sepinen, which I hurriedly had to write and place into the mail because I was given little notice about the upcoming hearing, and as a result was given little time to notify the Department of Licensing and Regulatory Affairs about what I intended to argue as my case at the upcoming hearing. This, I found later, was to be the pattern and practice of the DHS agents, so to put me at the disadvantage. At any rate, in my rush to put together a package of information and mail it to the Administrative Law Director, Sepinen, I discovered days later that I had inadvertently sent my original through the mail and kept the intended mailings at home. Notably, and because the package I accidentally sent to Sepinen at the Michigan Administrative Hearing System had original documents that I did not intend to provide at the hearing, I entered the hearing first with the intent to request the return of my property and trade for the document that I had intended for the administrative law judge to actually be sent. Here is how that meeting got started. Note that when he refused to provide me with either the return of my originals and then also refused to provide me with copies of my originals before beginning the hearing, I began reading my letter to the Director Sepinen, which was, for obvious reasons, a letter of objection and protest to these proceedings based on specific just cause reasons.
Sir, before we get started, Manny?
Me what?
I just noticed that those the documents that you have there are with the green tabs, and I wanted to let you know that when I put my stuff into the mail to Mr. Sepinen, that I accidentally put in my documents, which is my property, to him by accident, and I brought what was meant to go in the envelope with me. And I'd like to either make a trade-off or get there was some supplementary materials that I had in my originals that I was not intending to produce today. And I wanted to get a copy of that, or else get the original and then a trade-off with you. And with my apologies.
Comfortable, Mr. Shayad, is that how you pronounce your name?
Shayad, you got my apologies on that, but I did put my property into an envelope by mistake that should have been saved for me, and with this package going to Mr. Sepinen.
I don't think it's appropriate that I hand you documents that are part of the case file at this point, Mr. Shire.
Well, then I'd like to get a copy of everything that I just...
That's reasonable.
Yeah.
Let's get this going here. I have a feeling this is going to be a while, so let's get it started. This is registration number 1601160, matter of David Shire. Is that how you pronounce your name?
Shide.
Shire. The hearing is scheduled for Thursday, September 15th, 2016 at 3 o'clock p.m. I'm Administrative Law Judge Christian Gardaki.
hearing this matter today. I'll be hearing it in person from a DHHS office in Oakland County District Number 3. Could I please have the name, spelling of the name, and job title for those persons testifying for DHHS?
Michelle Silas, M-I-C-H-E-L-L-E, last name S-I-L-A-S. I'm the hearing facilitator.
Benjamin Smith, B-E-N-J-A-M-I-N, Smith, Assistance Payment Supervisor.
Not you, Mr. Scheid. Who are you, sir?
I'm Cornell Squires. I'm a friend of David Scheid.
Spell your first and last name.
Cornell, C-O-R-N-E-L-L. Last name is Squires, S-Q-U-I-R-E-S.
Before I hear any testimony, I swear in all witnesses, Ms. Silas, Mr. Smith, Mr. Scheid, and Mr. Spoyers, please raise your right hand. You, Mr. Scheid.
I am reverting back to the original documents that I gave to you. Do I understand that you are going to be providing me with copies of everything that I provided to you in that envelope?
Mr. Scheid, right now, I'm going to swear you in as a witness. I don't want to hear any other responses at this point. You'll have an opportunity to raise that later in the hearing.
My name is David Scheid, and I'm here in an objection and protest of these proceedings taking place at this time. My objection, protest is based upon fraud, uncooperativeness, and inconsistencies against me by the state of Michigan. The fraud against me amounts to a railroading of this hearing as shown by the correspondence I mailed to your executive director, Christopher Sappinen, on September 8th of 2016. That's in this file, and what's in my file is something more, and that's my property. The uncooperativeness and other inconsistencies, as well as the fraud, as well as more details about the reasons for my objection and protest are listed in that letter dated 9/8/16, which is in my hand today for your review. That's in case you didn't have my copy. For those written reasons now in the state's possession, this meeting should be postponed for 2 more months. That is all I have to say today.
Shall we review here once again what this entire hearing was really about? It was about who has superior control of whom, as reflected in the spirit of cooperativeness and the willingness or unwillingness of either party to be transparent in the conduct of their affairs. Notably, despite that the very first thing I requested upon walking into this hearing meeting room was the return of my original documents or a copy of the documents that I had inadvertently sent through the mail by mistake, some 45 minutes later, all 3 of these DHS agents were still attempting in bad faith to proceed in the hearing without providing me with my own property or copies of that property. Here, at the end of this meeting, DHS hearing facilitator Michelle Silas tries to even enter additional documents at the last minute to purportedly prove that I had been uncooperative all along, without acknowledging that my uncooperativeness and my ex-wife's uncooperativeness stemmed from the DHS attempting to force her and I into accepting the DHS's definition of, quote, household, unquote, that we had every right to challenge, using a divorce decree issued through the Michigan judiciary, albeit through just another corrupt Michigan judge. What follows is that when I asserted I have my own proofs that the DHS manager, Benjamin Smith, and his sidekick Silas had been uncooperative in spite of written assurances to me by the DHS on the purpose of the pre-hearing that played out earlier, this administrative law judge, Christian Gardaki, promptly ends the meeting, and only then does he provide me with the documents I required at the very beginning of this so-called administrative hearing.
The department would like to enter into the exhibit, even though it probably won't be considered, a series of documents pulled directly from Mr. Scheid's case file showing an ongoing pattern of non-cooperative and combative behavior with regards to the department's following its own policies and procedures and requesting information.
Do you think that's necessary to establish with me, Ms. Silas, at this point?
We have it if it's necessary. I wasn't sure. Otherwise, I have nothing else.
I have proof Benjamin Smith and Michelle Silas conducted an unfair and uncooperative pre-hearing meeting, which is a blatant violation of the represented, in writing, purpose and intent of that meeting as being a, quote, an attempt to resolve the issue, if possible, unquote, about, quote, what was the first name of Mr. Williams, unquote, who Michelle Silas had stated had engaged me in a phone conversation over the summer, and Benjamin Williams refused to reveal that first name by repeated claim that Mr. is indeed Mr. Williams' first name, and that not only is his name Mr. Williams, but that the DHS, being Smith, acting in a private capacity as a belligerent, does not need to cooperate with me, but instead I need to cooperate with DHS, i.e. Smith, as a belligerent.
Mr. Scheid, I don't recall ever dismissing a case because of a client that was just so combative that a hearing could not be conducted, but I believe today's circumstances warrant that action. I am going to dismiss your case due to your incapability and or unwillingness to answer my questions. I would ask if there's any response.
I object. I am answering your questions. These questions were even pre-answered, and I demand my property back.
Well,
I have ample proof of other fraudulence and inconsistencies about that correspondence of DHS, that they continued providing benefits, this goes into what she just got through saying, to me in spite of my ex-wife's refusal to comply with their demands.
I'm going to respond to what you said.
For information, I'm not finished what I'm saying, on multiple occasions. I have one such letter, wrongly dated, that was sent to DHS case manager S. Lilly over a year ago, along with a verification of assets form of Barbara A. Scheid to complete that was sent to me.
We're now looking at the merits.
Note that the 2015 letter, page 1 of 2, points out that I have been protesting.
Make a copy of the envelope, please. Mr. Scheid,
yes, sir. I'm
putting it on the record that you will receive a copy of everything within the case file that I have.
Thank you.
And you will receive that, and we'll go off the record.
For the record, it should be known that from the time I entered this hearing meeting until the end, I stuck strictly to my objection and protest plan by reading from the written letter that I had sent to the Administrative Hearing System Director, Christopher Sepinen, which Gardocki had in his possession but provided me no indication whatsoever that he had actually read that document, which I was commanded by DHS to have into the possession of Sepinen's hands a week before that meeting, just so that this so-called administrative judge would have the time to read it. But yet he didn't. So stay tuned for part 2 of this RICO Busters episode, where we show more of the state's pattern and practice of criminally depriving we the people of our due process rights through intentional fraud, through outright force and coercion, through the intentional construction of misleading records, and through the so-called professional behaviors as what was displayed by this Michigan judge at what was supposed to be an impartial administrative proceeding.
With an admission, only in parentheses, that the request was actually received on June 21st, demonstrating a deliberate amount of circumvent FOIA laws and not subject to a 2-month delay. Response to the request for documents needed to prepare for this hearing.
See you soon.